Welcome back to the Fordham IPLJ podcast. I'm your host, Patrick Ho. On this week's episode, IPLJ staff member Michael Rubin sits down with Jeffrey Berkowitz, a partner at Finnegan, Henderson, Farabow, Garrett, and Dunner. Their conversation touches on a variety of experiences encountered during Mr. Berkowitz's patent practice for nearly 30 years with his firm. Mr. Berkowitz discusses his international practice assisting clients, developing strategic patent portfolios, and litigating in district courts and the Court of Appeals for the Federal Circuit. I hope you guys enjoy this episode.
Hi, this is Michael Rubin, a staff member at IPLJ. My guest today is Jeffrey Berkowitz, a partner at Finnegan. And thank you so much for being on the podcast.
Glad to be here as well.
It's very nice. Okay, so I do have a bunch of questions I'm going to ask. And I guess first I'll start off with, could you tell me a little bit about yourself and how did you end up getting into patent law?
So I finished my undergraduate degree in computer science, and I applied to law school as an alternative to becoming a programmer at the time, which is really what the path that I was on. I enjoyed computers. I enjoyed the classes I took in the computer area, and I really did want to find another career that I could use at least some of those skills. So I applied to law school. I went to law school, and during law school, in my second year, I did an internship with a judge at what was then the United States Claims Court. It's now the United States Court of Federal Claims, Judge Marion Blank Horn. And I had a really good experience working with the judge. I learned a lot. And while I worked with her during that summer, she had a number of patent cases. And I thought, well, that was interesting. And then I went back to school and finished my third year. And I had applied to a clerkship to work with her. And I got the clerkship. I went to work with her for a year when I was through with school. And lo and behold, there were a number of patent cases that she had again. And to put it in context, these were all patent cases in this particular court. So the judge had a number of patent cases, and she had one patent case that was tried while I was in the court. It was a case where a company sued the United States government. So we were working on this patent case, and it was a lawsuit against the United States government for patent infringement. And the case involved these bomb loaders. It was actually, think of like a forklift, and the forklift was specially designed for loading bombs into airplanes. And in this case, they were the B-52 bomber and the B-1 bomber, and you had to have a special kind of forklift for these bombs that would go into airplanes. And frankly, it was really, really interesting. So I got to watch all this drama unfold in the courtroom, actually, when it was being tried for a couple of weeks, and really learn a lot about patent law at the same time. Now, I have to say the story of why I chose to go into patents, it would be incomplete if I didn't mention the fact that my girlfriend and fiance and later my wife, her father was a patent attorney all this time. And so even during that time and before, he would always like to talk to me about patents and stuff like that. So there's no question that also played a role in my going into patents. And then sort of like the final link to it is after I worked for the judge, I had an interview at Finnegan Henderson, and I really liked the culture, the atmosphere, and the group of attorneys at the time, and I really thought that it was a place and an area of the law that I could really use the skills, the technical skills that I had developed, spent a lot of time developing in computers, and combine it with the law.
Mm-hmm. Oh, wow. Okay. So I guess now I'll just ask, tell me a little bit about what you do specifically.
Okay, so my background, as I said, is in computers.
Right.
Right. So a lot of the work that I do involves computers in some form or another, whether or not it's computer hardware, software, handsets for telephones and things like that. I help companies secure, manage their patent portfolios related to their technological, inventions in those areas, their innovations, as well as I help companies that are asserting their patents, as well as defending companies when they do get sued for patent infringement. About 75 to 85% of my time is in litigation, and the rest of the time really is in the patent prosecution and management. I started really doing, it's somewhat unique in that oftentimes when people in the field go to work for firms, is they really, and this is more the case I think today than it used to be, is they pick an area that they're going to practice in, whether or not they're going to help companies with their preparation and prosecution of patents, or they go into litigation. I was kind of fortunate in my timing, really, as well, in that I was able to do both and to continue to do both for almost 30 years now. So I started out learning how to draft patents, and I also started out working on litigations in my firm. My firm is a unique, maybe microcosm of attorneys in a way, and it really just worked well that I could do all these different things, and there really wasn't very much tension between one and the other. And that really stemmed from really a principle, I think, that our firm still follows, which is that, the best prosecutors really do have experience litigating patents. And at the same time, the best litigators have experience prosecuting patents. It's this idea that you really need to know both sides or both of these different areas of practice in order to do either one or both really well. And that's why to this day I continue to have a mixed practice like that. So I started out drafting patents for computer companies that no longer exist mostly. I wrote patent applications for the Amiga computer that was developed by Commodore. I did patent applications for Digital Equipment Corporation, another company that doesn't exist anymore. I moved on over the years to do applications in the telecom area as well. All this time I was also working on various different litigations in my firm at the same time. Bigger companies that I did portfolio work for have been Sun Microsystems, SAP, Verizon, BlackBerry, a number of others.
Do you like one more than the other?
That's a good question. There are times where I do like one more than the other. They both have challenges, and I think that's really honestly one of the best things about the career for me has been that I've had to experience these different challenges in different areas, and you also get to learn new technology. Honestly, you get to learn new technology a little bit more when you do preparation and prosecution work versus the litigation work. Litigation work has been more adversarial for the most part, of course, and of course the preparation and prosecution is not. So that's the reason why. Sometimes I like one, and yes, sometimes I like the other more. But honestly, having the opportunity to do both the way I have has been really the best part of my career in a way, in that I get to really work with companies developing their innovations, understanding new technology areas for them, helping to strategize and develop strong patent portfolios for them, and at the same time working with companies both in asserting their patents and defending.
If there's I I only know from personal experience, but in times like I always think that I also have a background in computer science, and one day I remember like my boss said to me, like, do you think that you would be able to handle, it was not necessarily pharmaceutical related, but somewhat on the spectrum between like computers and pharmaceuticals or anything like that. Do you ever think like, oh, I could like even expand more and more like as one moves into a different field or something like that?
Well, there are certainly some skills that you learn over time that enable you to provide, the support and services to clients, right, in different fields, sure. I think that might be certainly the case more so in my experience in the litigation area than necessarily in preparing and prosecuting patents. You really do, in my opinion, have to have that sort of technical background to, I think, really effectively do the right job for clients in preparing and prosecuting applications. A lot of that also comes from the fact that you have to be able to communicate with inventors, right, in a science, right? Inventors, aren't going to want to have to teach you, some of the basics on, chemistry, for example, if it's a chemical related matter. So I think that's where at least some of the necessary, that you need to really have that necessary background. Now, having said that, I certainly have worked on matters over the years that haven't been in my area of technical expertise. I worked in a number of semiconductor cases. I prepared and prosecuted semiconductor applications. I worked on some medical device applications over the years. And in the litigation area, I've worked on some chemical cases and even one pharmaceutical case at one point early on in my career. It's good experience to really see some of the other areas of the practice from a technical standpoint as well. I should say, having said all that, my firm at the same time is really divided among technology groups. And so I'm in our electrical practice group, which covers things like electronics, obviously, semiconductor, software, computers. We do most, all of the stuff, all of the work related to telecom. I mean, all those different areas in my group. And we have about 100, I think that's about right now, between 100 and 120 attorneys, professionals in that group. That's all we do in that group.
Wow. Oh, wow. Okay. I guess for now, I'm actually going to try to just dumb it down because I wanted to get to this to make sure it's mentioned for our listeners. Can you describe in layman's terms what a patent is, why it can be useful in business and stuff like that? I just want to cover everything so that anyone listening would get the idea. If they don't know what a patent is, why get it? What's the point? Stuff like that.
Sure, I can try. I hope.
You seem qualified.
So, patents, of course, is one form of intellectual property, and there's a process by which you apply for patents. But typically people talk about patents using analogies to things like real estate, deeds, and fences, and things like that. So I'm going to put it in that context, right? So a patent is very similar to like a deed, right? The deed describes the property that you own, right? Old deeds used to describe the property that you own by describing the perimeter of the property. Newer deeds, of course, are simply a lot in a particular location, and that's the area that you own. And of course, patents, like the deeds or to real property, they enable the owner of that property to prevent people from trespassing on that property, right? So if I own a piece of property and I can keep people off, that's what the ownership right really gives you the right to do. And that's exactly what a patent does, really. And that's what patent infringement is, right? If somebody goes on your property, then they're infringing your property, and that's what patent infringement is about. Now, oftentimes, similarly, people describe patents also in terms of fences around that property, right? And the goal of any real patent attorney really is to develop that fence around that property that is so strong as to prevent anybody from going on to that property and trespass, and using the same analogy, and get away with it in a way, right? So the whole point is to be able to protect that property in such a way that it really is not possible for somebody to encroach on that property and get away with it. That is, that if you have the patent, you can either stop them, right, in many instances by seeking an injunction in court, or of course getting money damages for them doing that, because typically if somebody is going to be encroaching on your property, oftentimes you may be losing some value as the patent owner, particularly in situations where there's two competitors that are in a particular market. One has the patent, of course, is suing the competitor.
Mm-hmm. Okay, so I guess I'll start with, I actually looked this up, and the cleaning solution, fun fact for the people listening, WD-40 actually doesn't have a patent on their thing. Now, I could be wrong, but I believe that's the case. And they do not have a patent because they don't want to let everyone know how their cleaning solution comes about. Similar to the Coca-Cola formula. Everyone knows what's inside it, but they don't know at what percentages and so forth. So from my understanding, that would be a trade secret. Something where people are they don't want to have to disclose it completely, but it's something that they keep proprietary. So what would be, I want to say, the differences between obtaining a patent and keeping a trade secret, like pros and cons of both?
Okay, so
if I got it mistaken, by the way, you could totally correct me.
Other than WD-40 being a lubricant, other than a cleaning solution, I think you said.
I am completely off on that one.
There you go. So, yeah, no, it's a great question in that oftentimes when you work with innovators, you do consider whether or not a particular innovation that they may bring to you and they may want to patent is really something that should be better kept secret. Mm-hmm. Right, because there is a balance, as you described, between a patent and a trade secret, and that a patent requires that as part of getting the patent, you have to describe to people how to make and use your invention. Right, so you have to describe that secret formula, as you put it with the WD-40 example or the Coca-Cola. Right, and so in certain instances, certain kinds of innovations, right, where maybe the proportions of the chemicals that are being combined, right, are not easily reverse engineered, right? In those instances, of course, it may be better to maintain whatever the innovation is as a trade secret rather than have to disclose it as part of the patenting process, right? So that's really what the difference is. So patents, of course, you have to disclose it. The way to think of a patent in this regard is really, it's a contract, okay? You enter into a contract with the United States government. And in return for the right to exclude others from practicing your invention, right, you have to disclose certain things to the public. Now, why are you disclosing those things to the public? It's really so that the public can build on your innovations. Right, so I'm now disclosing it to other people so that they can now improve on what I developed. Mm-hmm. Right, so that's the contract. Right, now trade secrets. There are other aspects of trade secrets in order to maintain them as trade secrets that we obviously we're not touching on now. But trade secrets, of course, you don't have to disclose it. Right, there's other things you need to do in order to maintain the trade secret. But you don't have to disclose it. And so the real key here you can hear is the distinction is this disclosure, right? Patents require disclosures, trademarks don't. So I'll give you a simple example. In the software area, I said that my background is in software. I'm going to give you a software example, right? So if looking at the process in a computer, right, if looking at the output that's, for example, displayed on the screen, right, doesn't tell you precisely how you got to that process, how you got to that output, why would you want to disclose necessarily the specific methodology to get to that output, right? So ideally, when you're patenting software, for example, you want to describe a way of getting to that output, right? But ideally, you want to really claim it broad enough to cover all ways, right? On the other hand, getting back to our trade secrets, there are often processes that you don't want to reveal so your competitors won't know precisely how that operation occurs. So oftentimes some people refer to them as a black box type of process, right? So if I sell something to somebody and, let's say they plug it into their system, right? There's a box, you plug it into the system, there's inputs that go in and outputs that go out, but nobody really knows the process to get to those outputs from those inputs. That's an example of a process that's really in a box where you don't want to disclose that to the public. Right, so very often there is this discussion in developing portfolios with companies in the computer and telecom area. Really, that maybe that particular innovation is not something we want to disclose because we don't want competitors to understand that process. Again, it's this distinction between finding a balance between disclosing innovations, which is of course required for patents, and maintaining things as a trade secret. There are other aspects to trade secrets that really go into the requirements that you need to maintain them as, in fact, secret. Right. So oftentimes companies say, well, I'm just maintaining this as a trade secret, but they don't actually go through the procedures, set up the procedures and maintain the procedures that may be necessary actually to protect the innovation as a trade secret. Trade secrets can be equally valuable to companies when they, in fact, follow and set up procedures to maintain the trade secrets, in fact, as secret.
Okay. So I guess I should ask what's very important, because I think, I guess a lot of people listening are wondering how do you go about, when you're going about getting a patent, is there something that they could do it themselves? I know there's a patent agent, you could go through either a lawyer or a patent agent themselves, but is there something that someone like a normal person could just go online and fill out a form and that'll be it? Or do they need to go through a patent agent, a lawyer? What are the options?
Yeah. So you certainly don't need a lawyer, and you certainly don't even need a patent agent. Inventors can apply for patents on their own, and it certainly happens where they do. And there are certain requirements that have to be complied with. They're all set forth on the Patent Office's website in terms of the process. There are certainly some forms, but you also have to prepare a detailed description and claim and specify the invention at the end of the application with claims. I think really the crux of this comes into a lot of people, scientists, developers, innovators, engineers, they can certainly draft technical descriptions and disclosures, and often do so as part of their jobs, really, and probably most often do very, very well in those technical descriptions. However, patents really are not just technical descriptions; they're really legal documents, right? And that's really that's the key, really, is that because they are legal documents, having some training on how to draft them and how to develop claims that cover innovations is really kind of the key. And that's where the training and expertise comes in that you mentioned that patent attorneys and agents gain over time. It's not something that you necessarily learn overnight or anything like that. Having said that, I mean, there's nothing that would prevent individual inventors, of course, from applying for patents. In my own experience, you do see situations where individuals have applied for patents. It's fairly apparent as compared to professionally developed applications and patents in the first instance. And oftentimes you do see individual inventors, running into traps, if you will, by perhaps being in some instances penny wise and pound foolish, if you will, by not actually seeking professional assistance. It's like I often use this example when I talk to new clients sometimes, really, but not so new clients as well. But, if you're having brain surgery, okay, would you go to any doctor, right? Would you go to any engineer? You'd go to a brain surgeon, right? You go somebody that would have experience in how to perform that particular procedure, right? Because it's an important procedure, and you certainly don't want to make mistakes. And so it really is something like that where, you really do need to have a professional at least provide some level of assistance so that in the end, the product that you have is hopefully a very valuable product.
Wow. Okay. I guess I should ask, maybe this is just something I personally want to know, but a typical day. I'm going to what's a typical day? Okay.
So typical day, of course, after I take the dog out for his morning walk, and I'm at the office, it really does vary depending on the particular projects that I'm working on. Right now, a typical day is I will spend about 8 to 10 hours working on a number of different pending litigation matters that I have right now. Right now, I have 2 cases right now that are in discovery. So there are a number of discovery disputes that we're dealing with. And one of the cases in the next couple of weeks, we have an exchange of claim terms for claim construction that need to be done at the same time. So in more recent days, I've been spending a lot of time in analyzing the patent, analyzing the file histories for this patent, analyzing the claims, and identifying specific claim terms that may be useful in our defense of our client in this particular case. Our client was sued for infringement. And so, of course, we're looking for aspects of these claims that our client does not, in fact, perform in their particular applications. This is actually an application that's used on cell phones right now.
Wow. Is there any big cases you can talk about, or something that in the past that sticks out to you?
I've had a number of really great experiences over the years, and so there's not one that I would necessarily say or pick out as better than another.
You went to law school.
I did go to law school.
I can tell right now.
Having said that, I worked on a case that went to trial in East Texas this past spring. There were a lot of challenges, and it was a very interesting case that I worked on. There were about I think conservatively 8 accused products, 4 different patents, various variations of these patents, multiple claims in all but one of the patents, I think. We had a trial. We had witnesses from our client that testified. We were defending their client in that case. The case is Intellectual Ventures versus FedEx. And so Intellectual Ventures asserted a number of patents against FedEx. And so we were defending FedEx, and we had this case where we went to trial, and we had experts that testified and experts on damages that testified for both sides. And there were a lot of challenges, readying that case for trial, as well as on a daily basis during the trial. And we were successful in the end in defending FedEx in that case. Intellectual Ventures sought nearly $100 million in damages in the case. And it was a hard-fought case on both sides. And in the end, at the end, the jury came back in favor of FedEx. 4 of the patents were held not infringed, and 3 of them were held invalid as well.
Oh, wow.
And the whole process really is really very interesting from start to finish. Developing the case, developing the defenses for the case, implementing those defenses, of course, as well as dealing with adversaries, attorneys on the other side, all good adversaries. Really, having better adversaries in the way on the other side makes the case even more interesting, because it certainly makes it more challenging. And so that case stands out, of course, because of its recency as well. From that case, we also challenged the patents in that case in the patent office. Mm-hmm. There were originally 5 patents that were asserted in the case. 4 of the patents were challenged in the patent office using the inter-parties review process that began in, I guess it's maybe 2012, through the passage of the American Invents Act. In the patent office, we also were largely successful in invalidating these patents as well. So we're now dealing with the appeals from the patent office, and eventually I suspect that there will be an appeal from the district court case that we won as well.
Wow. A lot of appeals. Wow. So I guess as we're moving forward, I just want to switch gears a little.
Sure.
Because I know a little bit that you do a lot of speaking engagements and patent seminars all around the world, especially in Israel. And I was wondering if you could just talk a little bit about it.
Sure. So my firm began in earnest to develop a practice in Israel a number of years back. I don't know if it's quite 10 years, maybe more at this point. There was a book written about the startup nation in Israel.
Yeah.
And so around the same time, it was actually somewhat before that, but nevertheless, around the same time, we started developing practice in Israel, going to Israel regularly, speaking in Israel, of course, teaching classes in the universities in Israel, taught in the law school at Haifa University for, I think it's 5 or 6 summers when I did those classes. It really is a dynamic environment. And because of that, we've been very successful in developing a practice. I think there's about 150, give or take, clients that we have now in Israel in all different technology areas. Most notably, we do work for a company by the name of Mobileye that last year was acquired by Intel for, I forget the exact
15 billion.
Okay, 15 billion. And a number of other autonomous vehicle companies that we've worked with there. We do a good amount of work in the cybersecurity area with companies in Israel, medical device companies there. Really, it runs the gamut in terms of the technology. Right now, I have a case in Israel where we're representing a software company in Israel in which we filed a 12 patent infringement case against one of their competitors here in the United States.
Wow.
It's really in terms of the speaking there is really it's a great it's a great place where people just want to learn. At least it's my experience there. I'm not saying that there aren't, of course, other places where people want to learn. It's just my experience there is, we'll give a seminar, a talk. Somebody else will arrange it, and we'll be there and talk on the various different subjects. And everybody is just eager to learn, of course. And that's true of most of the programs. It's just a really fast-paced environment, and really companies start and close frequently. But it really is a great place to help to develop companies in terms of their IP. It's been a good experience. Is there anything else regarding that you had a question about?
Yes. Actually, you written an article on the Finnegan website about strategies for companies to get the most out of their patents. And I wanted to know if you had anything like following up what you think is what are the best ways that companies can in effect forward their patents, the best strategies for companies.
So I think the way to look at patent strategies is oftentimes when companies, startups maybe more so than developed companies, oftentimes when they apply for patents, they're really just applying for patents for the sake of being able to tell people, investors, for example, and most particularly, that they have patents, right? They don't necessarily, we sometimes describe it as a check-the-box patent, right? It's just simply checking the box that they've gone through this process, that they can tell investors that they have applied for patents, right? Not very much further thought is necessarily given to those patents that they get. Obviously, this is not universally the case. This is just, a general experience that we've seen. So really, when we talk about developing patent strategies and developing a portfolio with a strategic forethought, is really looking at developing patents really that really are focused on blocking competition and really adding value to the company. Right. Mm-hmm. So what do we mean by that is that, you can get patents on a lot of different things. I used to tell clients that, almost anything we could get a patent on, honestly. But the real question in the end is how valuable is that patent, right? And if the patent is easily designed around, for example, then obviously the patent is less valuable than a patent that is more difficult to design around. This is one of the reasons why they talk about standards essential patents as being so valuable. Why? Because if they cover a standard, then if you're practicing the standard, you have to use that patent. That's why it's called a standards essential patent. It's a patent essential to the standard, right? So that's a potentially very valuable patent because you have to practice the standard. You can't design around it. Often that's another reason why, for example, patents in the pharmaceuticals area are also typically very valuable. Now, the pathway to those patents is different in many ways from the pathway to obtaining patents in other areas of technology, right? But oftentimes, pharmaceutical companies will file for patent applications, and over a period of time, a prospective drug will go through various different trials and clinical trials, and ultimately would be approved by the FDA, hopefully. And so once it's approved by the FDA, the FDA, in a way, gives that company a monopoly that follows the pathway of the patent, right? And so, again, that patent on that drug becomes really a blocking patent. Why? Because the only way to develop another drug that satisfies the FDA for administration for whatever the condition or disease or whatever it might be, would have to go through this FDA process, but that whatever that drug is now protected by this patent. Mm-hmm. So it's a parallel process in a way between the patents and the FDA. So that's another example, like the standards of a blocking patent, right? So ideally, those kinds of patents really aren't generally available outside of standards and pharmaceuticals and the like, right? So when you develop a patent portfolio for a company that in other areas of technology, you really want to develop a portfolio. It may be one, it may be several, it may be many patents that really block the competition in the sense of there really are few ways, hopefully no ways, of designing around the patents to copy whatever it is the product is of the client. So that's what we really talk about when we talk about the patent strategies that we do with clients. And it's a great process where we sit down with the clients, we learn. Another important aspect of this is making sure that you know about the company's business, right? So that you're really looking at it not just from the technical standpoint, but also from a business standpoint in many instances, right? Because oftentimes when a company develops a new product, right, the developer or engineer may have one view of how that particular product adds value in a particular field. How its innovation is why the people are buying that product, right? On the other hand, the business people may have a very different, or marketing people, for example, may have a very different view of why customers are buying that product. Mm-hmm. One example I've used in the past is an example that involves a hypothetical photocopy machine, mm-hmm. right? So an engineer of a photocopy machine, you ask him what's great about this new photocopy machine, and he'll start telling you about how this photocopy machine, has this particular kind of roller system that, I don't know, the paper feed is faster than any other photocopy machine in the market, right? On the other hand, the marketing person looking at the same photocopy machine that is out in the field selling customers will tell you that the reason why this photocopy machine is selling better than other photocopy machines is because the on and off switch for this particular photocopy machine is in the front instead of in the back, which is where the competitors put the on-off switch, right? Uh-huh. People want to be able to get to the switch to turn it on and off. If you put it in the back, it's more difficult than if you put it in the front. Mm-hmm. So the customer-facing, right, angle, or the business angle in some respects, of why that particular machine is better than the competition may be very different in many instances from the engineer's view. Uh-huh. So when you're developing a strategy, it really is oftentimes critical to have all the information so that you can develop strong patent claims in the end that really will block the competition, prevent them from copying your products.
So more than just one factor.
Exactly.
To take into account. We're almost out of time, so I just want to have two more questions. Just what are some tips you would give young law students looking like they're thinking about going into practicing patent law? Like maybe something that helped you, or something to keep in mind besides for taking the class.
It's a good question in that, there's a lot of different things that I think looking back that I would point to that really helped. I think finding the right balance of mentors really was a big deal. For me, when I say balance, in that I found some mentors that were particularly difficult, I will say, early on to work with. And honestly, that I learned a lot working with the more difficult mentors. At the same time, I had another set of mentors that I would say were less difficult, but equally challenging in many ways. And so the combination really of having and having a thick skin in a way to be able to work with the difficult ones and push through that really added a lot, I would say, because I can look back and I can on various different experiences, and they all really, I benefited from all of them, both the ones that were the difficult ones and that I persevered through it more so perhaps than the ones that may have been less challenging, at least in that way. And the other thing that I would say that I did was I never said no. with one exception, which I will explain. I never said no to a new project when I started out. I really thought that my role was just to learn and do everything. There was one time where somebody asked me, one of the named partners of my firm asked me to work on something, and I called him back. I remember this conversation pretty vividly at this point even. And I said, I'm not sure I have time to do this project. I'm working on all these other things, and I'm working on this, I'm working on this, I'm working on this, and I'm just not sure I have time to do that. I just don't know, but I really want to do it. And so he thought about it for a little bit, and he said, given what you've told me, probably shouldn't work on that project. And I'm telling you this little anecdote because it was also the worst one of the choices that I made in turning down a project. In that particular matter was to work on an appeal with Don Dunner. Don Dunner is one of the named partners of my firm, and at that time, for sure, and maybe even today, he has argued more patent cases in front of the Court of Appeals for the Federal Circuit, and before that, the CCPA, the Court of Customs and Patent Appeals, than any other attorney. And I think even back then, it was not just any other attorney, it was any other attorney and firm. So all of the attorneys in firms still didn't argue at that point more cases than Don did. So why do I regret it? I never heard from Don again to work on an appeal. So.
Okay. Wow. Well, I think the one thing I just have left is that I believe we're asking everyone on the podcast, what is your favorite piece of IP of the week? An interesting question, but book, movie, music, the Grammys.
Wow.
You could even go with voice note recording because this thing has been...
I don't, oddly enough, I don't really look at the things that I interact with on a daily basis and think of it that way. I don't really think of it as, well, this is one better innovation that I'm dealing with than another. It's just a hard call. When you started saying it, when you started asking the question, I was thinking, oh, I know exactly what I was going to say, which is I read a book recently, and I'm blanking on the title, but I read a book recently, and it was about the patent case that went on in the turn of, I guess, the 19th. It would have been the end of the 1800s, early 1900s now. It was a dispute between Westinghouse and Edison. When you asked the question, I was thinking, I'm going to tell him about this book right away. It was a great book. I really appreciated the book, and it was a telling about the intrigue and some personal views, etc., from the angle of the attorney that was representing Westinghouse in his challenges with Edison. Edison had the patents, and it was a dispute over AC, of course, and DC, and ultimately the AC technology from Tesla is what Nikola Tesla ultimately is what prevailed in that dispute. But it went on for a couple of years or so, and the book is really a great read. There aren't a lot of patent books out there, so
our niche market.
For the benefit of your listeners, one of my partners, James Barney, wrote a couple of books on patents as well, and they're also pretty good reads. I enjoyed them, at least in the patent area as well. So there aren't a lot that really tell stories that involve patents. novels like that, and so I really enjoyed that. Other than that, I can't really come up with any IP of the week for you.
That was
Sorry
perfect.
about that.
No, that's perfect. That's perfect. Well, thank you so much for coming on the podcast.
This was a lot of fun. Thank you.
Thank you so much. All right. Take care.
The Fordham Intellectual Property, Media and Entertainment Law Journal is a publication staffed by the students of Fordham Law School. Our faculty moderator is Mark Patterson. Our Volume 29 Editor-in-Chief is Jeffrey Greenwood. Our Managing Editor is Michael Rivera. A special thank you to IPLJ staffer Michael Rubin and his guest Jeffrey Berkowitz for making this episode possible. You can follow us at our Twitter, Facebook, and Instagram at Fordham IPLJ. Please rate, review, and subscribe on Apple Podcasts so you don't miss a single episode. You can also visit our website at fordhamiplj.org for daily content. I'm your online editor, Patrick Ho. Thank you for listening and see you next week.